Hi, I'm Greg Dell, the managing attorney of Dell Schaefer. I'm here with Steve and Jessup. How are you, Steve?
Doing well, Greg. Yourself?
Good. I want to talk about the Our Services section of our website and specifically talk about the different types of services we offer. I know we've done this video before, but it's been a couple years. The services haven't really changed, but I want to maybe talk about it a little bit more detail for people who are considering hiring us. And we'll go through as a summary the whole aspect of what we do, which is the application process, which is someone who's considering filing for benefits or isn't even considering filing or has already started the process and still needs help. The person who's on claim already, which we call the ongoing claim handling, and the denial claim, which would be somebody who either needs an appeal through ERISA or has to file a lawsuit for an IDI claim or also for an ERISA claim. And then lastly, we do buyouts. So let's start with the first thing, just going in the order of how things usually happen with these claims, which is the first thing is the application process. And we've done several videos and we have a whole section on our site talking about the application process. But what in a nutshell is the highlight of why it's important to have an attorney help with the application process?
I think the biggest thing is just helping control the flow of information, responding timely to the insurance company, and sometimes it's not so clear cut with dates of disability. There's so many factors that can go, whether it's an employer provided policy or if it's a private policy. Each individual application, even though it's the same basic factors, each one is completely unique. So the most important thing is just making sure that the documentation is as accurate, as complete as possible.
Right, I think that's the application stage is the most critical. That's where somebody can really make a mistake that can affect them all throughout the claim, because choosing that date of disability is critical. Getting the appropriate medical support out of the box is critical. Making sure you're documenting everything with your doctors, making sure how you communicate with the carrier. There's so many things that can go wrong right from the beginning. And as you know, that's when the carriers put the most scrutiny on the claim, because if they can deny you up front, why the hell not, as opposed to later on. So I suggest you take a look at our videos on the application process where we talk about the specific types of assistance we provide for you when you're applying. So the next level is the ongoing claim handling, and that's the person who is on claim is basically saying, I'm tired of dealing with the insurance company, I want someone else to deal with it. Talk about what we do in that scenario for a claimant.
Well, first and foremost, if during that phase, in most phases actually, we advise the insurance company, that they're not to contact the client directly. That way they don't have to worry about receiving random phone calls, or you hear a lot of times they get threatening letters. If we don't have this information by such and such time, we're going to terminate your claim. So that is basically the process of complying with all the requests for information from the insurance company, coordinating with doctors, making sure to get medical records. Many times when people do call us and they're sick of dealing with the insurance company, it's very common to hear they keep requesting stuff from my doctor. My doctor says he sent it. They said they never get it. Or all of a sudden they're not getting this information from the doctor's office. So it's really just making sure that any of the tactics that an insurance company would use to try to justify denial of benefits is avoided, and also understanding the policy provisions and language, if there's going to be limitations in the policies, changes in definitions with regards to your occupation, not only focusing on that given month, to secure the benefit, but what are you going to do 5, 6, 10, 24 months down the road to make sure the client has the best chance of his benefit being continued.
Right, I call it that basically we always have your back. And I also have called it insurance on insurance, because we offer very affordable fees to offer that type of service, and always making sure that we're doing everything, staying ahead of the insurance company and staying ahead of our own client to make sure that they're getting the appropriate treatment so everything stays documented in order to keep the benefits coming. Also, like you said, that change of definition is a critical thing where the carrier is looking to try to deny benefits because the definition is going to change, and we help the claimant to address that and hopefully overcome that change in definition. Okay, so again, we have some other videos on that. You can certainly watch those on ongoing claim handling, and call us and ask us what we think. And we'll tell you if we have a claim where we don't think you need our assistance or you're just never going to have an issue. There are some of those. We'll obviously clearly let you know. The other area gets into the denial of claim. And you have ERISA and non-ERISA. Obviously, most of them are ERISA. Obviously, we also do the individual disability, and we've talked before about what the difference is between ERISA and non-ERISA. And so the first level, if it's ERISA, is you have to do an appeal to the company. And in a nutshell, why is it critical to have an attorney help with the appeal?
The appeal in most insurance companies, not all of them provide a voluntary second level of appeal. You get one chance of trying to quote unquote prove your claim. In the administrative appeal process, you are trying to justify why you are entitled to continued benefits, why the insurance company's review was incorrect, but most importantly, it's if you only have the one level of appeal. If an insurance company denies that appeal and you didn't have an attorney to be able to assist in figuring out what information needs to be added to perfect the claim file closes. And what that means is when you file a lawsuit, you're no longer able to provide any new additional information. And a lot of times you hear from people where they say, well, the claims person said I just had to write a letter as to why I disagreed,
right,
and everything would be fine. Well, that's not the case. Essentially, for all intents and purposes, the appeal is going to be an argument that you try to make in front of a judge. So you really want to make sure you have as much possible information as possible. I sometimes tell my clients or prospective clients, it's like stockpiling weapons for a war you don't want to have to fight with an insurance company. You want to be able to provide so much that they just decide that it's best to, maybe, go after someone else and leave your claim alone.
Right, and I also, it's funny you have your analogy, but I also talk about that we have our toolbox and all the different tools that we can use to try to present the appeal in a timely, well, not in a timely manner, but in the best manner appropriate for the claimant to be able to win their claim, because we look at the file and say, okay, we saw you were getting treatment and your doctor was doing the bare minimum to document that, but there's so many things that the doctor can be doing and other tools out there that we use, such as experts, other types of diagnostic testing, consultants that we work with, case law that we may or may not choose to use based upon what we know the insurance company is doing that's violating their rights. So there's so many options for a claimant that they just don't know about, and they get taken advantage of because the insurance company says, go ahead and send us in your appeal and we'll review it again. Well, you do it and then they deny you because you didn't do everything, and then we go to file a lawsuit, which we'll talk about in a minute, and we're limited to what you had done, the claimant had done on the appeal. So there's a lot of things that can be done on an appeal, and when you get denied, you request your claim file, you get 1,000 pages minimum, and then you got to start trying to present that, which is why they give you 180 days to do the appeal. On the individual disability denials, we usually don't do an appeal. If we think it's fruitful, then maybe we'll try. If not, you're going to be looking at litigation or some kind of pre-suit negotiation. So let's talk about the litigation aspect, which is we've done the appeal or the claimant's done the appeal, and now the only thing left to do is file a lawsuit in federal court, which is where 99.9% of these go. And what should a claimant expect when filing a lawsuit?
Well, it depends. I think the vast majority you'll see is the ERISA group disability policy. So when it comes to what to expect when filing a lawsuit, I tell the client, don't expect what you see on TV. You're not going to be allowed to testify at trial. Your doctors aren't. There isn't going to be a jury. Sometimes the judge doesn't even want to hear from the attorneys when rendering a decision on it. I tell them to expect that a federal judge is going to give us a series of dates. We say thank you. We don't get much input in that. And it's a matter of trying to just present that limited amount in the administrative record, for purposes of the judge. Also, I've yet to see a case that isn't going to be, set for some type of mediation. The insurance companies are going to want to discuss settlement process. Most federal court districts require mediation. So there's this weird kind of influx where the client, I always tell them, especially if they say, is this really worth my time? I always say it's not worth your time, in the sense it's not going to impede on their day-to-day life. And like it would in the sense of a private disability policies, where the rules for open discovery and all these things are going to be much
Right.
more in depth and time consuming.
Yeah, depositions, interrogatories, requests for production. Whereas in the ERISA arena, which is most of these cases, once we file a lawsuit, there's really absolutely nothing that the claimant has to do. We'll handle everything. And the other thing is that 95% of these ERISA lawsuits that we file end in some kind of lump sum settlement where you don't even end up going to the court.
Mm-hmm.
But if you do have to go to the court, it's basically a trial on the papers. Again, the claimant's never going to have the opportunity to go to court. You don't get a jury trial, which is a big disadvantage. And then we're always dealing with the notorious standard of review, which I'm sure if you've been on the internet or watched our other videos, you're dealing with that arbitrary and capricious standard, which basically means did the insurance company act reasonably in their review? Not did they get the decision correct, but was their process for reviewing the claim reasonable? And that's the part that we argue with, with Congress and the House of Representatives and everything at the federal level all the time, to say that these ERISA discretionary clauses should be deemed illegal, which it has been in about 15 states, and that it's unfair to claimants. But for the vast majority of states where we help claimants, they have to deal with this arbitrary and capricious clause. So that's something obviously we'll discuss when you call us, but if we're willing to accept your case, which we're selective in the cases that we take, then we feel that we can either win benefits or get you money. So that's something that we definitely want to discuss with you. The last aspect outside of the litigation is you're on claim for many years and you're interested in a lump sum buyout, or the disability carrier has called you and offered you a lump sum buyout. And there's probably, of the 40-something disability carriers, there's about 10 or 15 of them that will routinely offer lump sum buyouts or look to negotiate lump sum buyouts. And so when we're involved with those types of things, we have in-house contacts where we can try to get you a buyout. We know the dollars that they have available when you get into things like reserves and mortality, and the risk that they associate with a particular claim. So we're able to negotiate you top dollar for your buyout, even if you've already been offered a settlement offer from a company. That's something that you should do. You should call us and we'll help you to get as much as possible in that kind of claim. And again, if you've been on claim for years, there's so many pros and cons. And again, we have buyout videos that you can review in which we'll discuss your different options for a buyout. But definitely call us and we can even let you know right away if we think you're a candidate for a buyout, because there's a lot of different medical conditions, the carrier, so many different criteria to even determine if you would be eligible for a buyout. So this is just a brief summary where we touch on all the different levels of service that we offer. Important, obviously we're not Social Security disability attorneys. A lot of people call us and say they want help with Social Security. That's not what we do. We're private disability insurance attorneys. We go after insurance companies when you either bought a policy on your own or you got it as a benefit from your employer. So call any of our attorneys, call Steve, call myself. We're happy to provide you with a free consultation, and we can usually let you know immediately whether or not we're able to assist you. We look forward to the opportunity to help you.